Hello everyone, my name is Sakshi and in today's Law Wednesday, we would be discussing legal terms. Now, you would be wondering why are we not discussing a particular concept or a particular topic and why specifically legal terms? Well, I have a reason for that. As we are approaching CLAT 2024, I would want you to be preparing holistically for your exam to an extent that you are well aware of not just the topics, certain concepts, but also certain legal jargons, legal terms, legal phrases which you will find as a part of your passages, as a part of your questions. Now, why are these important? These are important because if there are certain terms given in your passage which you are not aware of, it makes it difficult for you to comprehend the passage, one. Secondly, while you spend a lot of time comprehending it, you would miss a crucial time answering the questions. So to ensure that we do not get trapped in that particular loop, the best is that we make ourselves aware of everything basic that is possible. So without talking any further, let's go and understand the first legal term, legal phrase we have for the day. The first phrase that we have is beyond reasonable doubt. Now, what is beyond reasonable doubt? So this is a terminology which is used in case of criminal trials. Whenever there is an accusation on a person, the prosecution is supposed to go through each and every aspect of that particular act. And if during the accusation, during the trial, if there remains a certain question unanswered, then the person cannot be convicted. So if you have to understand it through an example, let me help you understand with a story. So for example, person A has committed some murder. And while person A has committed some murder or person A is accused of committing a murder, there is a dead body which is received. There is bloodshed all over the place, blood stains in the house or in that particular area. Blood stains from the clothes that Mr. A was wearing. There was a crime weapon found at the crime scene, a big knife. And even the knife had blood stains of the deceased. Now, all these things are pointing it towards Mr. A's conviction that Mr. A has murdered the person, the dead person here. But when the entire investigation was done, it turned out that the fingerprints on the knife was not of Mr. A but of somebody else, because the fingerprints did not match with that of Mr. A. Now, this brings us to a question that if the fingerprints are not missing, is there a third person involved? Is there more things that we are not able to look through into that act? And if there remains certain questions unanswered, that means until we find the answer, until we have a concrete answer to each and every question during the investigation, we will not be able to convict Mr. A. So the idea is that any person who goes through the conviction process and is convicted in a criminal trial, his act or his crime should be proven beyond reasonable doubt. Innocent until proven guilty. So to explain this, I'll give you a situation. So for example, there is a hit and run case that has been reported, and it turns out that Sallu Bhai was driving the vehicle. Okay, now this may coincide with a very popular case that you would have, heard, followed or whatever. But yeah, just to give you an example, just to help you understand better and also help you remember. So there's a incident that has happened. It's a hit and run case, and it's alleged, it's said that the driver behind the wheels was Mr. Sallu Bhai. Now, Sallu Bhai was presented to the court. An entire trial was, taken place. And today is the last day of the trial. Now, the entire media, everybody related to, reporting is gathered outside the court. Sallu Bhai walks inside the court and everybody knows that today is the day of verdict and final decision would be made. Now, the decision was supposed to be out at 11 a.m. Every reporter wants to be the first one to report it. And then there is Miss Sanjana, who has been pressurized by her boss to bring all the masala news, to bring everything best possible on the table. So during this pressure, while she's waiting for the, final verdict to come in case of Sallu Bhai, she lost her patient. She went live on the camera saying that we finally have the verdict. I would want to show you the face of the murderer, the person who brutally killed 4 people on the road. And here is the person who has done that. And while she's reporting it to the camera, there's a video playing in her background where Sallu Bhai is walking inside the court. The video, a small clip that they have taken in the morning when he went inside the court. Now, this particular clip and news went viral. But what happened was, in the court, certain documents were missing, certain questions remained unanswered because of that beyond reasonable doubt thing. And court did not go ahead and give the judgment. The judgment was preserved, the judgment was kind of postponed to a later date. And the case was at the moment adjourned. Now, when Sallu Bhai came back to his home, only to realize that there's a media clip, getting viral, getting trending everywhere, where some women named Sanjana from a media house is calling him a murderer, is calling him a person who's actually responsible for the death of 4 people. Sallu Bhai, agitated by this entire thing, went ahead and filed a case against Mrs. Sanjana. Now, when the case was filed, Ms. Sanjana, the question was, whatever she reported, was it true or not? The question was, no. Simply because until the things are proven beyond reasonable doubt, until the court says that yes, XYZ person is a criminal, since the court says that Mr. Sallu Bhai is the one who killed these 4 people, none of us in the entire country or world can go ahead and say that X or Y or Z or Sallu Bhai or whatever is a convict. So, a person has to be treated as innocent until the person is proven guilty. So, basically, a rule of thumb as a part of criminal law that until and unless the conviction is not proven beyond reasonable doubt and it's not been said so by the court of law, the person will always be considered as innocent. So, innocent until proven guilty. The next term we have is burden of proof. Now, what is burden of proof? It's a basic form of trial where I am questioning, or if I am going and stating a fact, or if I'm going and telling that, this person has done XYZ act, the burden is on me to prove that this person has done it. And this burden keeps shifting. So, when a trial goes ahead, there's a prosecution and there's a defendant. Prosecution is the body which brings in all the accusation that, Mr. A has done a murder, Mr. A has done this, that, whatever. When Mr. A is being accused of certain things, it's the duty of the prosecution to prove each and every statement that they make in court of law. Once prosecution has done that, the burden shifts on the defendant to prove that whatever prosecution has said is wrong. And the other responsibility is, when you say that it's wrong, it's incorrect, you have to bring in documents, you have to bring in evidence to prove your point. And this is nothing but a burden of proof. So, it's a very simple rule that whatever statement you make in court of law, you should be backing it with the set of evidence. And when the burden is on you to prove the things and you have proven it, that is when the burden shifts on the other party. And this burden keeps shifting back and forth till we reach the point where the act is proven beyond reasonable doubt and the court convicts the person completely and the person is no more innocent. So, it's all interlinked. So, it starts with burden of proof. The burden of proof helps us proving somebody's act beyond reasonable doubt, and that is only the case when we say the person is proven guilty. The next is safe harbor immunity. Okay, so if you have gone through the CLAT 2023 question paper, there are certain terms that you would have come across: safe harbor immunity, surrogacy, because these were the terms used as a part of passage. Now, there was a passage related to some IT rules, acts, and that is where they used this terminology. And it had a really good significance in that passage. Now, the point is, I don't expect you, neither the CLAT consortium expect you to go through the entire laws that we have in the country, because they specify that they will not be testing your legal knowledge. But they give you passages which has certain terminologies which are very much part of the statutes, very much part of the law. And that is where you will get stuck. So, you will have to go through these terms and make yourself well aware of. Now, what is safe harbor immunity? Safe harbor immunity basically means that if on my platform, I am letting multiple people use my platform for their personal or private or social or whatever use, anything that they post or anything that they put on my platform is solely their responsibility. It's solely their headache and it's none of my responsibility. So, for example, if something is being tweeted on Twitter which may be derogatory, which may be defamatory. So the one who has tweeted something would be responsible and not Twitter as a company or as an organization. And this is nothing but it's a kind of umbrella, it's a kind of blanket given for the platforms under IT Act, and it's specifically given under Section 79. The next term is adjournment, something that I used couple of minutes back. Now, what is adjournment? Adjournment is nothing but postponement of case. Yes. So it's not like that it's only our classes or, at times our exams or at times certain events get postponed or cancelled or rescheduled. Even the court hearings have to adjourn. The reason could be just varied. Maybe the judge is not available, maybe the parties are not available, maybe certain documents are not ready, or maybe certain documents or evidences produced are not enough. Whatever be the case, whatever be the reason, every time we kind of postpone the hearing or the trial or the court proceeding, we call it adjournment. The next term we have is adjudication. Now, adjudication is a very common term from the English language, but used extensively in law. In fact, a lot of passages you will get regarding the procedural laws. There's a high possibility that this term will be there. Adjudication is nothing but the power or the authority or the competency of a party or the body to hear that case. So I'll give you an example. Suppose there's a family court, okay? The family court is supposed to hear cases related to divorce, family, properties, testimonies, different level of, the maintenance that is given, maybe child custody, all such matters which are related to family law. But if I have a case of check bounce, which has nothing to do with the family law, which has nothing to do with any of the family related stuff, and I take my check bounce case to the family court, will they be entertaining me? The answer is no. Similarly, if I take an environmental related issue to a tribunal which is completely for railway claims, so will the railway claims tribunal be entertaining me for the environmental violations? No, because there is a competency attached to every court. There's a competency attached to every body, and for this competency we use the term adjudication. So if you get a question where you have to look for the adjudication or you have to look for the competency, you will have to see what area the person or the body is designated to work on, and if the question asked is within that area or not. The next term we have is summon. Now, summon is a very commonly used term, and in fact, you would have heard it a lot here and there, especially if you have watched Suits. Summon is nothing, it's an order by the court to present yourself in front of the body. So, for example, a case is going on and which is related to let's say it's a case related to dowry death. And when this woman lost her life within 7 years of marriage due to the dowry demand and through, some act of in-laws, there was a neighbor who people say was a witness to this entire event. Now, this neighbor has been asked to come to the court to record the statement. So, what does this mean? The neighbor is summoned to the court. That means the neighbor has been asked to come to the court, present himself or herself in a physical manner, so that court can go ahead with the proceeding, maybe asking questions, maybe demanding documents, as and when the case requires. So anytime a court requires a person to be present in the court summons that person. The next term is a very, very common and popularly used terms in the last 2 to 3 months. If you have at all followed the legal current affairs in the last 3 months, or if you are actually preparing for CLAT and ensuring that you are well aware of everything that is happening around the legal fraternity, trust me, recuse and recusal is a term that you would have come across. In fact, a lot of Supreme Court judges have used this term, news have used this term. Now, what does this mean? This simply means that if a case is been assigned to a judge and the judge thinks that for any personal, professional or whatever reason, he should not be a part of that case because him being a part of case will only bring biasness to it. That is when we call that it's a case of recusal and the judge will step out from that case. So I'll give you an example. I am a judge who is, kind of into dealings with 2 companies which are getting merged. Now, something went wrong during the merger and acquisition, and the case has been brought to the court. Now, when I am going through this entire, case of two companies getting merged together, my own son-in-law is the CEO of one of the company. Now, my own son-in-law is the CEO of one of the company. If I have a professional work to do while it has some family connection and some family biasness to it, am I the right person to adjudicate this? Am I the right person or the right competent body, adjudication, the competent body to go ahead with the case? The answer is no. Because if my son-in-law is involved as a part of the deal and that case has come to me, even though I would say, I am not biased at all, I will be true to my work, there might be some biasness to it. And to ensure as a good judge that you make sure that justice is being served, the best is that you step down from the case and let somebody who comes from a complete different background with no strings attached go ahead and adjudicate the case. So recusal is nothing but a judge stepping down from a case, withdrawing from a case due to certain personal professional reason to ensure that there is no biasness. The next is ex parte. Now, ex parte is sounds like a very fancy term, but it's a very simple meaning. Ex parte means that any proceeding that has happened in absence of one party. Now, what happens if I have filed a case? The other party will be, summoned to the court for the reply of whatever accusation or whatever, things that I would have stated in my application. Now, the point is that if the other party doesn't show up, the court will give them a extended warning that, on this date, you should be showing up to the court. The other party still decides not to show up to the court at all. No representation, no lawyer, nothing, and the person himself also doesn't decide to come. Now, in this case, I should not be left behind. The court cannot say that, Sakshi, sorry, we cannot help you with your case for the reason that the other party is not showing up. Because if I have suffered any loss, if any of my right is violated, it's the duty of the court to make sure that my rights are restored. In this case, court will wait for a certain extent, give certain number of warnings. When the other party doesn't show up, court will go ahead and decide the case listening to whatever information I have provided to the court. And when this happens, it's called ex parte decision. That means in absence of other body or other party. The next and the last term to discuss is mitigating circumstances. Now, what are mitigating circumstances? Mitigating circumstances are nothing but certain facts, certain information, certain events which will kind of lessen the gravity or the situation of your case, or maybe kind of calm down or maybe settle down to your case to a certain extent. So, if I have to give an example, you are caught by your parents bunking some of your classes, okay? So your tuition teacher or maybe your school teacher, somebody just complained that, you were not in the class, you were not in the particular school while the classes were going on and you were roaming around somewhere else. Now you are in a bad situation. You are being caught red-handed and there is nothing that can help you escape from the beatings of your parents. Now, obviously, in your case, your parents don't beat you at all. Back in our cases, we used to get thrashed badly. But again, coming back, you might get a lot of good hearing from your parents. But if somebody comes and tell you that you were out because you were given certain task, or you were attending an event for the school and while you were coming back, you got stuck in the traffic, or something went wrong, the bus, tire got punctured, and because of that, you were stuck and therefore you could not make it to the class. And by the time you entered the class, it had already started and you didn't get an entry. And now the only way you could realize or you could thought of going back to home was once the class gets over and you can go back with your friends. So the time you got, because you had nothing to do, you were roaming around here and there. What is this? This is nothing but helping you mitigate the situation, helping you get kind of some leverage from the thrashing of your parents. This is exactly something that happens in each and every case. So when the case comes up, not exactly in each and every case, but generally in cases, when cases come up, if there are certain facts, certain information which kinds of diverts the case or brings in such information which tells that this person has done something wrong, but there's some other smaller, information attached to it, or something else, that act that is attached to it which made this person do it. That means, will you get some leverage here? Yes, you will get some leverage here. And that is nothing but mitigating circumstances. So this brings me to the end of this session. But before we end up, there's very important thing that I would want you to go through and also register yourself for if you haven't already. So we have come to the final round, that is mock test 3 for the CLAT Challenger Series 2024. We already have hundreds of registrations so far. The test 1 was conducted pan-India at all the IMS centers. Test 2 was conducted, and finally we are going ahead with test 3. The test 3 is scheduled for 1st of October 2023. It's a full-length CLAT pattern mock test. It's open for all the IMS enrolled as well as non-enrolled students. In fact, everybody writing CLAT 2024 should be attempting this. Why? Reason: your performance tracking, which you will be able to do at a pan-India level. So, rather than just competing at your own center or at your own coaching institute, you will get ranking for all the students, all the aspirants who would be writing this exam at pan-India. Secondly, a proper detailed performance analytics at the IMS portal, which will not just help you understand what went wrong and what went right, but also help you understand what sections are or sections or area that you are actually weak in and what are your stronger areas, which will further help you work for the next 2 months to ensure that you are well prepared before the CLAT. And the most exciting of all, you get a chance to win prizes up to 10 lakh rupees. Yes. So the winner or the highest scorer of CLAT mock 3 under the Challenger series will get a cash prize of 15,000. And once the series is over and your CLAT exams are here, if you score within top 50 AIR, you get certain cash prizes. So you get to analyze your performance, you get to take a step forward for the preparation of your CLAT along with winning cash prizes. So without wasting time, if you haven't registered already, please register. The link is given in the description. I'll see you in the next session. Thank you.